live, Justin. All right, welcome everybody to our second special live stream of this Wednesday. I'm here with Justin Olson from England Logistics. We're going to be talking about broker liability at the Supreme Court. But here, just to start off, we have to do our housekeeping. So let me start with our antitrust statement. So discussion, comments, and presentations during TIA functions must not, one, refer to any past, present, or future rates, prices, or anything related thereto. Two, including reference to marketing strategies. Three, include any discussion of any boycotts of any person, product, or firm, or four, inhibit any members or employees from discussing employment with other member companies. Things you hear during the meeting that are confidential and private to TIA must not be shared. I lost that part, but you guys know the deal. All right, so we are here with Justin. He's the VP of Legal and Risk at England Logistics. We're going to, like I said, work through some stuff, broker liability at the Supreme Court. So, Justin, let's just start off from the very beginning. Can you walk us through what this case is about, why the Supreme Court decided to take it up?
You bet. And Jonathan, I think that a little bit of background on broker liability cases in general will be helpful for the audience. I know we've got people of various degrees of knowledge on this. So these cases against brokers for liability kind of started coming to the forefront in 2004 with the Schramm case. And the Schramm case was about negligent hiring of a motor carrier. And in a couple slides, we'll go through that. So there's really three theories that come out. There's this negligent hiring. In other words, you didn't do enough due diligence or you made a wrong decision on the carrier that you hired. There's vicarious liability cases against brokers, and that is where the plaintiffs try to expand the circle of or sphere of liability, if you will. I think if you think back, I'm aging a little bit, but a lot of people on here probably remember years ago, decade or more, maybe 2 decades ago, the McDonald's case where the person at the drive-up window got burned with coffee, right? And so McDonald's is liable for the acts of their employee in serving that without warning. That's traditional vicarious liability. What plaintiff attorneys and claimants try to do in broker liability cases is expand that, and so that the vicarious liability or the liability of the employer for the acts of the employee is expanded to acts of independent contractors, which are different than employees. And the general rule is that someone who engages an independent contractor is not liable for those acts, but if they exercise control over how the services are performed, then they can be vicariously liable for the acts of that independent contractor. And we'll address that quickly in a few slides as well. The third theory that you see, not as common, but sometimes, is a joint venture theory. In other words, the broker, the carrier, the shipper were all engaged in a joint venture from which they would all profit. And because of that, they become a joint venture or a de facto partnership, and therefore they are liable for the acts of each other. So those are kind of the three theories. And if you want to move down a slide, Jonathan, we'll talk about negligent hiring real quickly. I'll try to sum up this rule. So like I said, the negligent hiring kind of took the forefront in 2004 in the Schramm case. These quotes are from a 2008 case, Jones versus C.H. Robinson, because they give the rule. As I said, the general rule is that one who employs an independent contractor is not liable for the injuries to third parties resulting from the independent contractor's negligence. But there were some states, like Maryland in Schramm, Virginia in Jones, that recognized exceptions for negligent hiring of independent contractors. So Jonathan's moved down. Okay, and so this is, there's a treatise out there, or what's called the restatement of torts. There's restatement of various areas of law. But the restatement said an employer is subject to liability for physical harm caused by his failure to exercise reasonable care to employ a competent and careful contractor to do work which involve a risk of physical harm unless it is skillfully and carefully done. And that restatement was cited by the court in the Jones versus C.H. Robinson case. And if we go down to our next slide, well, there it is. So, and then vicarious liabilities, I tried to explain that. This is how it was explained in the Schramm case. And by the way, of note, C.H. Robinson was successful in defending on summary judgment the vicarious liabilities claims in both the Schramm case and the Robinson case. So there were actually good cases for brokers in the area of vicarious liability. They just aren't good cases in areas of negligent hiring. So as I kind of explained, under this vicarious liability or respondeat superior, an employer is liable for the acts of an employee or an agent / independent contractor that is acting within the scope of that, what the law terms the master-servant relationship. And the crux to it is the right to control how something is done is the determining factor of whether vicarious liability will extend to that party that engaged the independent contractor, or in our situation, the broker that arranged the carrier. So go down one more slide, and I won't read this whole slide, but the difference between these, and this is a quote from the Spurl case, which was a huge case, $23.5 million jury award against a broker for controlling how the carrier and the driver performed their work. And what the Spurl court said is the difference between an independent contractor and a principal agent relationship is defined by the level of control of the manner. So just keep that in mind, vicarious liability. Scroll down on the joint. I think the next one is the joint. Yeah, so this is the partnership I talked about. There's defined statutorily in every state. A partnership is an association of two or more people who carry on a business for profit. A joint venture is kind of synonymous with that somewhat. They don't have to have a formal agreement. They just have a mutual goal. There's mutual risk. There's sharing of profits, sharing of losses. And that creates, by operation of law, a joint venture or a partnership. And the effect of that is that all general partners or all parties to the joint venture are liable for the acts of the other. So that's kind of a background of the theories that go on this. So, Jonathan, then we have what is referred to as the F4A preemption doctrine. So that's kind of a weird term, F4A, and you see it sometimes with an F and a numeral 4 and an A, but generally it's this. What that stands for is the Federal Aviation Administration Authorization Act. What the heck does aviation have to do with motor carriers and brokerage? Well, they grew out of the same scenario back in the early 90s to deregulate both of those industries. So the federal statute that's applicable to surface transportation or motor carrier broker transportation is a federal statute that's up here, 49 U.S.C. 14501. And the goal of F4A, this was enacted in 1994, the goal was to try to promote, Congress was seeking to promote the efficient and deregulated supply chain. And so they enacted this thing. They wanted to curtail the authority of the states so that motor carriers, brokers, freight forwarders, those that work in interstate commerce don't have to work with what has become referred to as a patchwork of laws. They can basically operate by one rule that is effective nationwide rather than states having different laws. So the F4A statute's enacted, and as you can see on the screen, it says a state may not enact or enforce a law, regulation, or other provision that has the force of law or the effect of law related to the price, route, or service of any motor carrier, and I kept some out, motor carrier important for us as broker or freight forwarder, with respect to the transportation of property. So you have to identify that law is going to affect the price, routes, or services. Well, what are the services a broker performs? It arranges motor carriers to transport freight. So that is the service that it does. And so these lawsuits that say, broker, you're liable for the negligent manner in which you selected a carrier or arranged a carrier to haul, that affects the service. Now, the courts didn't jump to that immediately, and I won't go into all of the background. There were a number of cases that said, no, this is too tangential. It doesn't affect that. It's just common law negligent claims. It didn't. But with the effort of a lot of brilliant champion transportation attorneys, we got it to the point that the courts almost uniformly now recognize that these negligent hirings do affect the prices, routes, or services of brokers. So, Jonathan, I don't know if you have questions or if we should jump down to this exception to that rule, which is the next slide.
Well, let's start. So now that we have a little bit of a background, Justin, what are some of the broker liability claims that are at issue in Montgomery in front of the Supreme Court right now?
Right. So Montgomery is the case that arose to the Supreme Court out of the Seventh Circuit. Now, the Seventh Circuit takes into account, we have a map later, but I'll try to go from memory right now. Illinois, Indiana, and Wisconsin, I believe, are Seventh Circuit cases. And so this was a case that came into one of the federal district courts there. The federal district court said, yes, this statute that we're looking at on our screen blocks the plaintiff, Sean Montgomery, from asserting a negligent hiring claim against C.H. Robinson as the broker. You don't see C.H. Robinson's name in the case. It's Montgomery versus Caride. Okay, but the broker involved is C.H. Robinson, who does a wonderful job blazing trails for our industry. Let's put it that way. And so the federal district court said, Plaintiff Montgomery, you can't sustain your lawsuit. We're throwing it out as a matter of law because under the law, you don't have a claim. That went to the Seventh Circuit Court of Appeals, Federal Court of Appeals, the Seventh Circuit. They agreed. And they said, we agree that this statute throws out your claim. So the plaintiff, Montgomery, appealed to the Supreme Court of the United States, or SCOTUS, as we sometimes refer to it. And C.H. Robinson joined in that appeal. They said, we want the Supreme Court, or I shouldn't say that appeal, the petition for certiorari. In other words, this is a petition or request that the Supreme Court hears the case. So the plaintiff requested that. C.H. Robinson said, yes, we want the court to hear it as well. So we're going to join in that. This was the fourth time that the Supreme Court had been asked to review a case. It happened in the Miller case that arose out of the Ninth Circuit, which is pretty much most of the Western states. It happened again in the Supreme Court denied. They did not grant the request to be heard. Same thing happened in the Ying Yi case, another one that came out of the Seventh Circuit, involving Global Trans, that Global Trans was successful on. The same thing happened in a case that came out of the 11th Circuit, which is Florida, Alabama, Georgia, in the Gauther case, and the court again refused to hear it. And so this Montgomery case was the fourth request. And I should say this, in the Gauther case out of the 11th Circuit ruled in favor of TQL. And the plaintiff appealed, and TQL joined in that one too, saying, we like the makeup of the court, we would like this to be heard. And it was denied. This time, C.H. Robinson was successful in getting the court to hear it. Now, there's also a request that will probably be just tabled or disregarded right now that's coming out of the Sixth Circuit that ruled against the broker, TQL, in that case, and TQL petitioned for cert on that. TIA filed a supporting brief trying to get the Supreme Court to accept that. That's not been decided, but it looks like it'll just be tabled because this case will decide the issue. But the Montgomery case will only address negligent hiring claims. It won't address vicarious liability or joint venture unless the Supreme Court really surprises us and expands that. But generally, courts are careful to keep it to the narrow issue that's before it. And in this case, that's the negligent hiring.
Gotcha. So how would their ruling clear the air one way or the other, right?
Okay, so maybe let's scroll down 2 slides. Okay, this is just a brief overview of the federal court system and the state court system. You see in the federal court system, there's the U.S. district courts. That's a trial court level. That's where lawsuits are filed. Then it goes to the U.S. appellate courts. Those are the circuit courts of appeal, and then the Supreme Court. So the Supreme Court will, from the federal court system, will be controlling precedent over all of the federal court system. Look in the other column. You have a state trial court. We just call it that because there's different names for it. There's state appellate courts. Most of them have an intermediate appellate court level. Then a state Supreme Court, and you can appeal from there to the U.S. Supreme Court. So the U.S. Supreme Court is the supreme law of the land, and it covers both state and federal court jurisdictions in there. And so hopefully that gives you an idea of it. And if you scroll down to a couple other slides, maybe the next slide right here, this is just a map of the federal court system and the geographic boundaries. You see the different colors with the numbers. Those are the circuit courts of appeal. You can see how much geographic area a circuit like the Ninth Circuit covers, whereas, like the First Circuit covers Maine, Massachusetts, Rhode Island, Connecticut, 4 states, but not a huge geographic area. And then the little dotted lines, you'll see in Texas, for example, there are 4 different districts: the northern, the western, the southern, and the eastern. So some states have more than one district court, whereas you look at New Mexico, Colorado, Utah, Wyoming, right there next to them, there's one district court for the entire state. So if you can go back up 1 slide really quickly, Jonathan. Actually, 2 slides. One of the things that's at issue, I mentioned that the courts pretty much uniformly now say that negligent hiring falls within the services of a broker. Therefore, it's covered by the F4A preemption principle or the F4A preemption statute. But there's an exception to that, and that is that preemption principle does not restrict the safety regulatory of a state with respect to motor vehicles. Okay, and so, you kind of geek out on a phrase of a footnote in a court opinion, or at least attorneys do. But most of this confusion comes over these 5 words: with respect to motor vehicles. And so as we go down a couple of slides, I'll show you the confusion this has created because courts have ruled on that differently. Okay, this slide right here. These are federal district courts, the ones shown in yellow, that have had adverse rulings to brokers on F4A preemption, and that is based on that phrase, with respect to motor vehicles. The safety regulatory authority of the state with respect to motor vehicles. So, you see that. The next slide, shown in green, these are states that have ruled favorably to brokers in F4A cases and basically say, sorry for the little note there in the middle, apologize for not getting that out, but these are states that have ruled favorably to brokers on the same issue. Then go to the next slide. The ones shown in red are federal district courts that have issued opinions both ways. They conflict with themselves. Different, a district court has multiple judges. One judge might see it one way, another judge another way. So the districts shown in red have conflicting opinions, some favorable to brokers, some unfavorable. So then go to the next one, and it shows you something. Okay, remember back when I said that the Congress's purpose in enacting the F4A statute was to eliminate the patchwork of laws that motor carriers, brokers, and freight forwarders had to deal with. when we put all of these different opinions in the federal district court systems here, this is what you get. To me, that looks like more of a mosaic than even a patchwork quilt. It's confusing. And that's what F4A was supposed to try to avoid. So there's a visual background of the confusion that we currently exist in. This is at the district court level. Click down to the next one. That'll show us at the circuit court level. So this shows the federal circuit courts. The ones in yellow, the Ninth Circuit and the Sixth Circuit, have ruled unfavorably to brokers. The Ninth Circuit ruled that way in the Miller case back in 2020, 2021, one of those 2 years. The Sixth Circuit ruled against brokers just in July of this year. And so, very recent. The Seventh Circuit, shown in green, ruled in favor of brokers in 2023 in the Ying Yi Global Trans case. The 11th Circuit has a bit of a history. That was in it started in 2023, then continued in 2024. The 11th Circuit issued an opinion that was a cargo theft opinion in favor of brokers in the 11th Circuit, but they expanded. They were more active in their opinion. They expanded that, said it doesn't matter if the damage or loss is to cargo or if it's bodily injury to a person. F4A bars it. And so it laid the groundwork for expansion of this. And then the 11th Circuit in 2024, just last year, in a Gauther versus TQL case, said, yeah, what we said in the prior case on the cargo theft, which was Aspen American versus Landstar, we're expanding, we're very easily expanding that to bodily injury cases, just as we did before. So you have two cases against brokers, two circuits against brokers, two ruling in favor of brokerage. I show the Fourth Circuit, which is West Virginia, Virginia, North Carolina, South Carolina, and the Fifth Circuit, Texas, Louisiana, Mississippi. Orange, that is because they currently have F4A cases pending in those circuit courts of appeal. They have not ruled on them yet. And in fact, in the Fourth Circuit, TIA filed an amicus brief in that one as well. So most likely those cases will be stayed and just nothing will happen, since the Supreme Court has granted the petition out of the Seventh Circuit in Montgomery, which was the second case that the Seventh Circuit ruled in favor of brokers on. And that's what goes up to the Supreme Court. So however they rule, the entire country will be either yellow or green as far as negligent hiring goes. It's the supreme law of the land, Supreme Court of the land, federal court, state court. It will cover all of that. And I should mention there are some state courts in the state court system. I'll use Illinois and I'll use California as examples. The cases, including the Montgomery case that came out of the Seventh Circuit, are controlling precedent in the federal court system in those three states of the Seventh Circuit: Wisconsin, Illinois, Indiana. It is not controlling precedent in the state court system. So right now, if you're sued for a motor carrier accident in Illinois, if you can get into federal court, you've got good binding precedent. If you go into state court, not so much. In fact, one of the state appellate courts for Illinois ruled in July that F4A is not a defense. And so Illinois has 5 courts of appeals. This was one of those that is located, that's over Cook County. So in Illinois, if you're in state court, if you're in Cook County, you have binding precedent that says F4A is not a defense. But if you're in federal court, you have binding legal precedent that says F4A is a defense. Same is true, only opposite in California. The federal court system in California, because of the Ninth Circuit ruling in the Miller case, says that you don't have a defense with F4A. But just a couple weeks ago, I think it was on the 9th of September, a California Court of Appeals that handles the Fresno area, and I can't remember which other counties, ruled F4A is a defense. and so how the Supreme Court rules in the Montgomery case will clear all of that up, either favorable to brokers or adverse to brokers. So that's what's at stake. There's a ton at stake. And like I said, I don't think that the court will expand to say this includes vicarious liability cases or not. They might, because vicarious liability claims are also based on state law, but they may not go that far. Most of the time there's judicial restraint, and particularly with the makeup of this Supreme Court.
Gotcha.
So that was a mouthful. I'm sorry.
No problem. So let's move on to contracts and compliance implications. So what efforts might the ruling by the Supreme Court prompt legislatively for us?
Well, I think I don't know that it's going to change what we do with contracts. Mm-hmm. Contracts are mainly geared toward protecting against vicarious liability, with some exceptions. And the reason I say that is like they would be looking primarily at your broker-carrier agreement in a vicarious liability lawsuit. What does the motor carrier care about in that? When am I going to get paid? What is my cargo liability? And do you offset for that? Right? And yet we end up with these 10, 12, 15-page agreements that I write myself, and have written in my years of practice, and then here at England, years of private law practice. Most of those provisions in those long contracts are to protect against third parties. You'll take 3 pages explaining that we're an independent contractor, and what that means is that everybody is covering their own costs, that they can't act as the agent for the other, all of kind of disclaimer language that the carrier doesn't really care about, nor does the broker, except for protecting against third-party claims from the public. That's been going on. Those have been going on for a couple of decades. I don't think contractually it will change. Legislatively, you asked, Jonathan, was the second question. Mm-hmm. I think this will be big changes, because if the Supreme Court rules in favor of brokers, you can bet on it that the plaintiff bar, the personal injury bar, and the safety coalitions is what they might call themselves, but the plaintiff bar will probably be lobbying Congress hard for amendment of the F4A statute to say this. And I'm not going to go into all the arguments they may have because of the broad audience of this. I don't want to do many favors. But there will probably be a very strong lobby for that. One thing that might grow out of that is it might create a more favorable or ripe environment to try to get Congress to enact what we've come to call the National Motor Carrier Safety Selection Standard, so that there is an actual target. And TIA's been pushing this for at least 15 years to try to get this. There's at least some clarity as to what are the standards that a carrier characteristics they must have, that we can have a safe harbor. Because right now we're shooting in the dark. How much is enough? How much is too much? Where are we at on that? On what constitutes negligent hiring? And so it may ripen some legislation to enact this Federal Motor Carrier Safety Standards Act, provision. Mm-hmm. If it rules in favor of adverse to brokers, in favor of the plaintiffs, so we don't have the F4A defense, then of course we're going to double down and triple down or quadruple down on our efforts to get that hiring standard enacted, and we may have more of an ear with Congress to do that, just because the environment that nobody knows how much is enough and how much isn't. Does that make sense?
Yeah. I guess one of the questions that I have is, why wouldn't the Supreme Court just go ahead and rule on all of that right now, just to make it super clear for everybody?
Well, it's kind of the balance of powers. So the laws are made by the legislative branch, by Congress. They are interpreted by the judicial branch, the courts. And so the courts don't want to encroach on the balance of powers. You see this battle everywhere right now, particularly with the last two administrations, where the executive branch is often accused of overreaching and throwing off their balance, both balance of power between the three governmental branches of the federal government, so legislative, judicial, and executive, and also encroachment upon states' rights, federal to states' rights. So one of the reasons why brokers and TIA and others have wanted the Supreme Court to hear one of these cases now is because of the makeup of the court right now. I'm not gonna cast it in terms of conservative or liberal justices. I'm gonna cast it in terms of those who, in their past jurisprudence and rulings as judges, have had a tendency to be more of what we would term in the legal field of a strict statutory constructionist. In other words, they are looking at the wording of the statute and they are trying to discern from that what the congressional intent was. They're looking to what did Congress say was the policy, the public policy, rather than being activists and trying to, through their court rulings, create new policy through expansion of that. And so we think that the current makeup of the court will look at the statutory language. They'll look at it in its historical context. If this is a time of deregulation, Congress was looking to undo patchworks and relieve motor carriers and brokers and freight forwarders of the burden of all these different states, this kaleidoscope or mosaic effect that we saw in one of the slides, relieve them of that so that we can have an efficient, deregulated supply chain. And I think they'll look to that. And some of the evidence that we as advocates for brokers will point to are this. This whole clause about with respect to motor vehicles was kind of a savings clause. In other words, we're going to preserve things. Well, negligent hiring cases had not really been developed at that point. So there was, and so they were preserving things like, if you look at the rest of that section, I won't ask Jonathan to bring it up, but it says things as the authority of a state to impose highway route controls, limitations on the size and weight of motor vehicles, regulation of hazardous materials through there, and so forth, the minimum required insurance through there, things like that, not how somebody performs their service in a deregulated environment. So we think that gives us good argument. Another thing that we've argued in some of these cases, and when I say we, I mean the industry as a whole, the transportation attorneys and everything else, are that Congress, and through its delegation to the executive branches, put auto liability requirements on motor carriers. They have to carry $750,000 of public liability insurance to cover bodily injury and property damage. Neither Congress nor FMCSA has put that obligation on brokers. A broker's only minimum financial requirement is its bond. And to bolster that argument, in 2012, when MAP 21 was passed, the negligent hiring cases were more or less fully developed. They were out there. Everybody knew about it. Well, Congress itself reviewed the regulations of brokers, and it looked specifically, one of those areas, I mean, it was pretty expansive, but one of those areas was financial responsibility. They increased the bond from $10,000 to $75,000, the minimum bond requirement. They did not impose public liability insurance on a broker. And so reading into that, you can say, okay, given the wording of the statute, given the congressional history of when some of these have been acted, and an illegal principle or legal doctrine of congressional inaction, when you compare it to MAP 21, they had the opportunity and they declined to do so. Therefore, congressional intent must have been that brokers would not be liable. I hope that boils it down a little bit, but that is why even when brokers like TQL and CH Robinson have won at the Circuit Court of Appeals level, they have joined in petitions to the Supreme Court to try to get it there because the perception or belief, which again, it's just a belief, a perception. Those are brilliant minds of jurisprudence, and they have strong opinions, and they will express them, or they wouldn't be where they're at, right?
Yep.
So, but the perception is that that the makeup of the Supreme Court is that they will construe the F4A statute according to its plain language. They'll look at it in the context of historically what it's done, what Congress has done since, and that through that language and those indicators, they should rule that F4A preemption bars negligent hiring cases. That's our hope.
Gotcha. All right, let's. I know there's some people that are wondering what's next, and I know you were in DC a couple of weeks ago for the policy forum, right? So, what efforts does TIA have going on that are for this matter specifically, right? I'm sure you talked to a lot of people about that whenever you were in DC.
Right. So up until a year ago, so up until September 2024, we had some really informal kind of a in-house legal committee informal. And we brought part of that back in early 2024. In September 2024, TIA's board elected to make that an official committee. Within that committee, we have a subcommittee that we call the Amicus Brief Committee, subcommittee. And so when important cases come up like this, applications can be submitted to the committee and then to the subcommittee to say, hey, is this an issue that TIA should become involved in? Should we file an amicus brief? And what an amicus brief is a filing with the court that says, we are not a party, but we're interested in the outcome.
Right.
For example, England Logistics is not a party to the Montgomery Cribe case. C.H. Robinson is. But we're definitely interested in the outcome because the entire industry is.
Right.
Okay. If you're a broker, you better be interested in the outcome. Right.
Right.
And so we formed this subcommittee to look at amicus briefs. And I mentioned that TIA has filed a couple of amicus briefs. They filed one in the Fourth Circuit Court of Appeals on the F4A issue. They filed one with the Supreme Court in TQL's petition for certiorari to see if the Supreme Court would hear TQL's case that came out of the Sixth Circuit. We do have an application on this. The subcommittee is deliberating. They have a preliminary recommendation. I won't indicate what that is because it's got to go up through. That's a recommendation to TIA's executive committee to make that decision. But TIA is definitely involved in filing amicus briefs and getting more involved in doing so. Right now, those are funded by contributions from a number of brokers, mostly those that have people serving on the in-house legal committee, TIA's in-house legal committee. That may change in the future, but we have some steps to go through before we make any announcements or anything there. So there's the involvement with the courts. TIA will undoubtedly continue to lobby for a federal motor carrier safety standard. Unless the Supreme Court rules in our favor, then it won't be relevant, right?
Yep.
But let me say this: I think all of us that are TIA members and many other brokers in the industry are highly concerned about safety on the roads. We're highly concerned about it. It's not that we just want a get out of jail free card. We want to vet carriers in a safe manner, but we have no standard by which to go by. We've got no guidance.
Mhm.
I mean, in fact, legally, FMCSA is in charge of determining safety and licensing carriers, and brokers can arrange a licensed motor carrier. That's where it should stop. But unfortunately, with these negligent hiring cases, it hasn't stopped there. They've said, well, you should have looked at this, or you should have known this, or you should have done this.
Mhm.
But it's all the creativity, how creative a plaintiff attorney can get. Because, and I've said this for decades as an attorney, we don't have to be right as attorneys. We just have to be persuasive. you know?
Right. Yeah.
So I hate that cliche, but it is true. You just have to be persuasive, sometimes at different levels. So I think those are some of the things, Jonathan, that will arise out of it legislatively and TIA involvement with the courts.
Gotcha. I mean, we don't really know which way they're going to rule, right? So what are some things that brokers could be doing right now to prepare for either outcome, either way?
Well, I think you keep doing what you've been doing. You keep being careful in your contractual language. You continue to not make sure you're not called a carrier. Be careful of what you're indemnifying somebody for, if it's a negligent acts of the carrier or whatever it is. Have all of those things that set you out as a broker. Have your vetting procedures in place that you believe are reasonable. All of the things that you've been doing, even predating the Schramm case in 2004 because of the concern for safety, continue doing the same things. Timing wise is that briefs in the Montgomery case, even amicus briefs, will probably have to be filed by mid-December. So we're only about 8 or 9 weeks out of having those briefs filed. C.H. Robinson anticipates that oral argument will be held before the Supreme Court in early 2026. I don't know if that's January or February, but probably first quarter of 2026. And they anticipate having a decision probably during the second quarter of 2026. So in the next 9 months, we're probably gonna know a whole lot more of the confusion. But in the meantime, keep doing the same things that you've been doing to both promote safety and protect yourself from liability.
Good advice.
Hope that makes sense.
Yeah. As we get closer to wrapping up here, we always like to ask one last question. So if you had one piece of advice for brokers that are watching today, what do you think that would be?
That would be support efforts. I mean, there are TIA, I would say, would probably most likely be filing a brief on this, although that decision is not made yet. That's for the executive committee to make. There are other groups outside of TIA that are affiliations of brokers that file amicus briefs. You might look at that to file an amicus brief in there. If you're involved if you're involved with a lawsuit against you under these, you may want to, depending on the jurisdiction you're in, request that it be stayed, or you might want to try to hurry it up while you have controlling jurisdiction. But most likely, those courts, at the suggestion of one party or another, will say, well, we're probably just going to stay this case until the Supreme Court decides. Let's see, what other things should they do? Mainly keep doing the same things you're doing. Vet your carriers well, not just for fraud, which has been an enhanced thing with the spike of cargo theft. Continue doing it for safety, and do it vigilantly for safety. To the extent you can read, to the extent you can try to figure out what you should be doing, because there is no target. But look at that. There will probably be a reach out to other industrial groups, for example, and I don't know if these groups, these are just ones that come to mind, like Food Shippers or Nittly. These are shipper groups that arrange carriers. And there have been a few cases that have extended F4A to protect shippers and consignees from liability, even though they are not mentioned in the F4A statute. And so I think groups like that will also be interested in filing amicus briefs and watching this very closely.
All right. Well, Justin, we appreciate you taking the time to put all this together for us. I know it was top of mind for a lot of people when that announcement came out that they were taking this case up. So we definitely appreciate it, TIA. I know the members appreciate your guidance as well here. Just so everybody knows, this will be available on a replay, so you'll be able to go back and watch it in LinkedIn, on YouTube, those places where we're live streaming now. So if you missed any of this, or you need to come back and watch a little bit more of it, or review something that Justin said, it'll be available for you guys. We've got more coming up later this week and the weeks ahead. So again, Justin, thank you very much. We appreciate it. And we will see you next time.
Yeah. And thanks all of you out there for all the good work you do in this industry.
Yep.
Love the industry.
Yep. Thank you.
Okay. Thanks.